Now, the economic approach. It involves application of an economic perspective to socio-legal studies. Inspired by the capability approach of the economist Amartya Sen and by the work of political philosopher Nussbaum, the justification and effectiveness of socio-legal norms can be revisited. The capability approach has been developed in the field of welfare economics and particularly aims at promoting justice and human development. People's capabilities might be enhanced by human rights. The research in socio-legal sphere identifies ways in which capability could be operationalized within policy, including corporate responsibility, financial services, and consumer protection. Now, a discussion about the research methods. This part provides a general survey of the social and philosophical roots of the various techniques available for data collection and link the ideas involved to a student's initial review of the literature on how to develop a viable research question. Particular attention shall be paid to the contested issues in social science. Particular attention shall be paid to the contested issues in social science research, such as the following. What are we trying to achieve when we are engaged in research activities? Do qualitative and quantitative approaches have equal claims to be considered empirical? When we decide on which methods to use in collecting the information we need, what assumptions are we making and what do they imply? What philosophical approaches to these assumptions rest upon? What do the differences between the various approaches entail for the interpretation of the nature of knowledge and truth? How do these differences apply at the ultimate stage when research findings are used as evidence to support an argument and the completed text of the thesis must evaluate the validity of the initial research design? Finally, having surveyed the dynamic interplay between theoretical concepts and empirical data, researcher has to focus upon the importance of constructing a conceptual framework that will ensure the consistency and integrity of a research project. Quantitative methods in socio-legal research. The use of quantitative methods in socio-legal scholarship is ever growing. There is a growing trend towards empirical legal studies where empirical is defined as large N or quantitative methods. Participant observation. Participant observation is a type of research that could be regarded as diametrically opposed to the collection of quantitative data. This relates not only to the methods but to the types of questions that can be answered, the research design and the subsequent analysis of data. The researcher shall keep in mind the nature of ethnography and participant observation and consider how his or her research project may be placed on the scale between quantitative and ethnographic methodologies. A case study regarding about participant observation would help and places the researcher in a position to anticipate whether he or she might encounter any similar practical issues in their research. Interviews. The researcher shall focus upon conducting semi-structured and unstructured interviews. As to how to do it, tips, it can be drawn from experience in the field. The researcher shall be mindful of the distinction between individual style and of good or bad practice. Analyzing qualitative data. Qualitative data pose particular challenges for combining creativity and rigor in their analysis. Moreover, given that qualitative, in contrast to quantitative data, are often voluminous and unstructured, critical reflection of techniques for managing and interpreting such data is important. The techniques for the analysis of qualitative data are not theoretical tools, but should be located within theoretical assumptions about how the social world could be understood and researched. Finally comes the question of research ethics. Pertinent ethical issues may arise during socio-legal research. It is important to consider ethical issues and ethical thinking in social studies. This discussion has made you understand the fundamentals of socio-legal research and the components of which it is comprised of. It makes you appreciate the utility of socio-legal research. It helps you identify the potential areas of socio-legal research. It introduces the learner to the socio-legal field. It also helps the students understand the various approaches to socio-legal research from the perspective of sociology, anthropology, and economy. And it also introduces the students to various socio-legal research methods. Now let us recapitulate what we have learned so far. The socio-legal approach may be seen to occupy a space between two extremes of a methodological spectrum. At one end, a strict doctrinal approach relies predominantly on self-informed analysis of legislation and judicial decisions from the superior courts. Approaches at the other end, such as critical legal studies and economic analysis of law, are tuned to the concerns, theory, and informants of external perspectives. While contextual analysis is increasingly the norm in legal scholarship, external informants are essential to a socio-legal approach. The socio-legal lens widens to observe operational and everyday legal situations, and diverse textual sources, disciplinary, and cultural perspectives are considered. Thank you.